హలో హలో ఒకసారి చూడమ్మా లైవ్ లో వస్తాను వాయిస్ అని. హలో వస్తుందా వాయిస్? వస్తాను వాయిస్. పాప సెల్స్ మార్చు మార్చు.
It's 3-year LLB students present here, 3-year LLB general students. You have code visit today at 10:30. You can leave. So please, 3-year LLB general students. And it is only for boys, you can go directly to the court. You should assemble at court premises by 10:30. 3-year LLB general students, boys. Huh? Okay, you will physical biometric. Biometric. Students, please listen. You have to give your biometric attendance to Balaji at court premises. So make sure you reach court by 10:30. Guys, please listen. Please listen. Mike, serial Guys, please do listen. You have to assemble the court. Don't enter the court unless and until you have given the biometric. You have to go together. So once you've given the biometric, please stay there itself. You will be taken inside and make sure you be there by 10:30. And it is only for boys, LLB general. Is it clear? 3 years. And after court visit, you have your regular classes. You have to be here by 2:30. Clear? Asha. எது? I think this mic is working. This mic is working, but this isn't. The cooler. The cooler or the காத்து தான். No, I'll move this podium this way. But still, this isn't working.
Battery complete.
This is also not working now. Please settle down. It's coming. It's coming. Where is the mic? They had the button. பரவாயில்ல நீங்க வச்சுக்கலாம்ல yeah sure ma'am, I'll announce once they settle down. I'll announce. Is there 3-year LLB general students present here? Boys. 3-year LLB general students. Is anyone present here? Guys, please settle down. Is any 3-year LLB general students present here? Please convey this message to your friends who are in 3-year LLB general that you have court visit today only for the boys and they have to assemble at the court premises by 10:30. You shouldn't enter the court without the permission of the faculties. They will sort you out into teams and you will be sent to respective courtrooms. You have to give your biometrics and only then you have permission to enter the courtrooms. Please convey this message to your friends who are studying at 3-year LLB general. Is it clear? Please convey the message to your friends. This is the only opportunity you will get to visit court visit. So please convey this message. உங்களுக்கு attendance lose ஆயிரும், court visit cancel ஆயிரும். Shall we begin? Good morning to all. Good morning. So what? So what all portions we have covered so far? Starting from notice till then huh? Am I audible at the back? Am I audible at the back? Yes, sir. Is it? Is it? Chada. Honest. Yes. Yes, sir. Thank you, sir. Please settle down. So starting from notice till what all we have discussed. Yes. Huh? Statement then OP, all those things. Okay. Now, உங்களுக்கு நீங்க suit institute பண்ணிட்டீங்க. Maybe the either party would have the suit might either be decreed or suit either might be dismissed. Is it audible at the back? Backல கேக்குதா? Is it yes or no? So, after instituting a suit, say for example, plaintiff or defendant, அவங்களுக்கு either suit might have decreed or it is in the favor of the defendant. Or if the defendant had filed a written statement along with the counterclaim, and the counterclaim the defendant க்கு ஃபேவரா வந்துருச்சு. And say அவங்களுக்கு ஒரு decree has been passed. Now what is the next step they have to take? They have to proceed with. Decree கையில வந்துருச்சு. Say for example that Mr. X owes rupees 10 lakhs with interest. வந்துருச்சு. And also there is an attachment that has been allowed initially. For attachment petition இருக்கு. And say for example 5 lakh rupees decreed. Suit has been, court has found that the suit is maintainable and it has been decreed in favor of the plaintiff. So இதுதான் decree வந்துருச்சு. இனி என்ன பண்ணணும்? Execution. You have to execute the decree. That is what is actually execution. Yes, enforcement of the decree or realizing what is actually the court has decreed in favor of the parties. So, who's actually the decree holder and who's actually the judgment debtor? Is it plaintiff? Not in the scenario. I'm asking who's a decree holder. In whose favor a decree has been passed or order, an order or else an executable order is being passed in whose favor. So a decree holder is a person again for whom a decree has been passed or an order which is capable of being executed has been passed. So he is a decree holder. No, he could be a plaintiff or he could be a defendant, whatever it is. So then who's a judgment debtor? Someone at the back, please explain who's a judgment debtor. Yes? Who against whom a decree has been passed or against whom an order which is capable of being executed has been passed against that person. So there are two parties here. Judgment debt, decree holder and judgment debtor. Is it clear? Provisions are another clear. To clause 3, right? Decree holder. Fine. So from which sections and which order deals with execution? Yes. Someone at the back. I want participation from the back side. Boys. 21. Is it section or order? Yes, ma'am. Ennachu, ma'am? Fire. Others, please remain silent. Guys, sit down. At the back. So what are the sections that deals with execution of decree and orders? At the back, boys at the back. Yes, someone at the back. Which section deals with execution? All okay at the back. AC பிரச்சனை இல்ல. Once again, I'm asking you people which section and which order under CPC deals with execution, and I want answer from the boys at the back. At the back. You people even don't know the order and section with execution பத்தி தெரியாம ஆனா பேச மட்டும் உங்களுக்கு நல்லா வருது இல்ல பேக்ல இருக்கிறவங்களுக்கு எல்லாருக்கும். Section 36 to Section 36 to 74 and order 21 rule 1 to 1 to how many rules are there in section order 21? Yes. Why am I asking you this? Practice ஆரம்பிக்கிறீங்கன்னா that too if you want to practice as a civil lawyer. These sections and these rules has to be at your fingertips. Very, very important. நீங்க ஆர்டர் நீங்க கஷ்டப்பட்டு வருஷ கணக்கு நீங்க கஷ்டப்பட்டு வாதாடி you might get a decree for in favor of your plaintiff, but you don't know how and with which provision you have to file an execution. What is the use of that piece of paper called a decree? And the decree நீங்க execute பண்ண உங்களுக்கு தெரியலனா then what is the use of contesting a matter? These are all things that you have to apply in your day-to-day scenario once you enroll as an advocate. So please, இப்பவாது படிச்சு வச்சிருக்கீங்கன்னா you won't be like feel bad when you start to practice. இல்லனா to be honest, they might make a fool of you, your seniors. So under section order 21, how many rules are there? 106 rules are there. So a decree has been passed in favor of you, and at least he made an effort to look at his phone to refer and tell which section and order it is. What about the others? ஒன்னும் பண்ணல இல்ல. Okay, so normally if you want to start an even for filing a suit, what you have to do is you will send a notice initially. That is intimation that he is gonna start initial legal proceedings against you if you fail to do so and so, right? In while executing decree also, under only 4 circumstances, you are supposed to send notice to them. Fine. Otherwise, if நாளைக்கே உங்களுக்கு ஒரு டிகிரி பாஸ் ஆயிடுச்சுன்னா மறுநாளைக்கே after all the proceedings, after getting all the copies or the judgment degree copy கிடைச்சதுக்கு அப்புறம் you can file without intimating, without giving a notice to the judgment debtor. But under 4 scenarios, I will tell you the provisions, but make sure you go home and read it. Under 4 scenarios, you have to mandatorily send a notice that execute பண்ண போறோம்னு சொல்லி notice. We are going to initiate an execution petition against you under 4 circumstances. First one is Order 21, Rule 16. What does Order 21, Rule 16 says about? What do you mean by transferee court? Or a transferee of decree? Is decree an actionable claim? Then what is actionable claim? Answer me. Is decree an actionable claim? What is actionable claim? எதுல படிச்சீங்க நீங்க actionable claim? You people don't know nothing. You don't know anything but பேசுறதுக்கும் nuisance பண்றதுக்கும், make a fool of yourself. You are very good at it. சிரிக்கல, I'm being serious. Is decree an actionable claim or not? Yes. உங்களுக்கு ஃபேவரா ஒரு டிகிரி வந்திருக்கு. Say for example, you have எனக்கு ஒரு டிகிரி ஃபேவரா that Mr. X owes me 5 lakh rupee. இந்த டிகிரி எனக்கு இன்னொருத்தருக்கு கொடுத்துட்டு அந்த 5 lakh rupee எனக்கு வாங்க முடியுமா? Yes sir. Yes na answer வேணும், no நாலும் answer. Then give me the answer. Why is it no? I wonder how you pass transfer of property. Yes, tell me. You understood the concept, Sharon? Any doubt for you? Sharon, doubt? Actionable claim means if you go before a civil court, you will get a relief, right? Is this decree is executable? In the decree, or court of competent jurisdiction has passed a decree in my favor stating that Mr. X owes rupees 5 lakhs to me. Is this order or is this decree can be executed? Yes. அப்போ நீங்க ஒரு சிவில் கோர்ட்ல நீங்க இத போய் ஃபைல் பண்ணீங்களா, உங்களுக்கு ரிலீஃப் கிடைக்குமா கிடைக்காதா? கிடைக்கும். So it is an actionable claim as well. Actionable claim, section 3 of Transfer of Property Act, what does it defines? If you approach a civil court, you will be given relief. You will be awarded relief if you approach a civil. அப்படி நம்ம approach பண்ணி நமக்கு relief கிடைக்குன்னா those things are called actionable claim. And so, for example, I transfer my decree to another person. So now who's actually executing that decree? The third party, not the party whose favor the decree was passed, right? So if a person, the transferee of a decree, is filing the execution, he has to send a notice mandatory to the judgment debtor. First scenario, is it clear? Second thing, order 21, rule 22. What is order 20? நீங்க CPC exam எழுதுனவங்க தானீங்க எல்லாரும். You have completed CPC, right? Then what is order 21, rule 22? What is the time period for execution of a decree? What is the limitation for execution of a decree? Yes? Huh? 12 years. Okay. That is the limitation for executing a decree. What if in the case of mandatory injunction, what is the limitation there? Yes? என்னது கேட்கல. What is the limitation within which period you have to execute a mandatory injunction? Three years. Okay. So there are different but basically for execution the limitation period is 12 years. But if you execute a decree after after getting the judgment, 2 years gap to after 2 years you are executing the decree. Then what you have to do is you have to mandatorily send a notice to the judgment debtor. Clear? First is order 21 rule 16. Then 22. தயவு செஞ்சு இன்ட்ரெஸ்ட் இருக்குன்னா பிராக்டிஸ் பண்ண இன்ட்ரெஸ்ட் இருக்குன்னா போய் வாசிங்க. Clear? Next is order 21 rule 37. Order 21 rule 37 என்ன சொல்லுது? Under order 21 rule 37, what is section? Wait. What is section 96 says about supplementary proceedings? What are the different types of supplementary proceedings? One is injunction. Next, arrest before judgment. So section, that is what we are talking about. If you, in what all scenarios we can arrest a person before the judgment? That in the order la order 38 rule 5 is attachment before judgment. Rule 1, order 38 rule 1 says about arrest before judgment. So there are scenarios wherein the defendant, not defendant, the judgment debtor might abscond the premises or abscond the limits of jurisdiction of the court, or he might abscond to abscond outside the jurisdiction of India. So there are chances in order to delay the execution of decree, he might attempt so and so things, and also only in the case of payment of money. Money suit lana arrest as per what order 21 rule 37, you will arrest a judgment debtor. So before issuing a warrant of arrest, what the court has to do is you have to issue a summons to them that they have to show cause why he shouldn't be arrested. And you people are seriously testing my patience. Seriously, I'm winding up guys. I have no, like, sorry, live is going on. CPC எல்லாம் முதவே கத்து கொடுத்து உங்களுக்கு புரிய வச்சு பண்ணணும்னு எனக்கு நிர்பந்தம் இல்லை. But yet I'm doing it for your sake, and this is the response you people are giving me. At least interest இல்லைன்னா தயவு செஞ்சு ஒரு அரை மணி நேரம் பேசாம இருங்க. I'm done with you guys for today. Thank you.
Good morning. We have seen till now regarding to professional misconduct. Now let us see who is going to take actions against such professional misconduct has been dealt by the disciplinary committee. Note it down, disciplinary committee. So disciplinary committee will be in charge of taking disciplinary committee will be in charge of taking disciplinary actions against the professional misconduct of advocates. Now we have to see section 35, section 36, 37, where the disciplinary committee of the State Bar Council, disciplinary committee of Bar Council of India. It is, I repeat again, it is not Bar Council of India that takes action against those advocates who have done their professional misconduct. Excuse me. Okay. Now, section 9. Refer to section 9 of the Advocates Act. When we deal with section 9, Bar Council shall constitute one or more disciplinary committees. That is what been dealt by section 9 of the Advocates Act. Let us deal with section 9. I may go through section 9, please. Disciplinary committee. Bar Council shall constitute one or more disciplinary committee, each of which shall constitute of 3 persons, of whom 2 shall be persons elected by the council from amongst its members, and the other shall be person co-opted by the council from amongst advocates who possesses the qualification which we have seen in section 3 subclause 2, section 3 subclause 2, state bar council section 3 subclause 2, and who are not members of the council, and the senior most advocate among them, among the three shall be the chairman of the disciplinary committee. So note it down. Section 9 says that there shall be one or more disciplinary committees. Now write it down, please. Disciplinary committee, section 9 says that there may be one or more disciplinary committees formed. Now each of such disciplinary committees, maybe 1 or 2, let us consider 1. Each of that disciplinary committee will have how many? 3 persons. Shall consist of 3 persons. 3 persons. 2 of those persons are elected from amongst their members. From among their members. 1 will be a member from an outside member, who shall not be their member. That is the state bar council's members. Other person co-opted by the council from amongst advocates who are not the member of the councils. So thus there will be 3 members constituted in the disciplinary committee. Now who will be the chairman of the disciplinary committee? The senior most among them. The senior most person among these 3 will be the chairman of the disciplinary committee. That is what we have seen under this particular section, that is section 9 of the disciplinary committee. Now section 9A is not disciplinary committee, it deals with the legal aid committee. That is different from the disciplinary committee. Now let us deal with section 35 of the Act. Section 35. It deals with the punishment of advocates with regard to disciplinary commission. On receiving a complaint by whom? A complaint made by any individual to the bar council. The bar council, when it has reasons to believe that this particular advocate has done something which is coming within the purview of moral turpitude, or which is coming within the purview of professional misconduct, which is believed by the bar council, what can it do? Now that particular advocate is within the role of that particular state. His name should be there in my role. Whose role? The state bar council's. I am not dealing with the bar council disciplinary committee. I am now saying with regard to complaint is not received directly by the disciplinary committee. Complaint is received by the bar council, state bar council. Bar council has reasons to believe that this advocate has done something which is coming within the purview of professional misconduct. Then what shall it do? The concerned state bar council will refer this complaint to the disciplinary committee. That is the 3 members. It will be given to the disciplinary committee to dispose of. Now the date of hearing and fixation of the disciplinary committee's proceedings shall be notified to the parties. Natural justice. Likewise, the same procedure. Why it is having the power of the civil code under CPC. We will come across that. So it will give notice when the date, the time of proceedings, etc. will be notified to the parties concerned. Then after which, after hearing the other side, after hearing the case, according to the procedure established, the disciplinary committee has the power to render punishment. What all shall be the punishments rendered by the disciplinary committee? Either when the disciplinary committee hears the case, after hearing the particular case, the disciplinary committee may find that there is no ground In this case, what can it do? Dismiss the complaint. It may dismiss the complaint. Then give a warning to the advocate. Maybe give a warning to the advocate that he may not repeat it. Unconditional pardon may be pardoned by the side of the advocate. Unconditionally, he may pardon for the offense done. What is the objective herein? It is not only punishment, but also we want to correct the person, correct the advocate here. So we want him to correct himself. So unconditional pardon may be given on the side of the advocate, whereby the concerned bar disciplinary committee may warn the advocate and leave him. Admonitions that we have seen in section 320, if I am not wrong, criminal procedure code. Say next one is suspending the advocate from further practicing. Suspending him for a limited period of time, as may be deemed fit. By the disciplinary committee feels that he need to be suspended, not just warned, but he will be suspended from practice. This suspension period, he will be debarred from practice. During this suspension period, maybe 1 year, accordingly, whatever it is deemed fit by the disciplinary committee, he may be suspended from further practicing. So once he is suspended, you are being suspended from practicing. You are not allowed to practice before any court, appear before any court, any person, any tribunal. That is how the wordings are used in accordance to in section 30 of the Advocates Act. Now removing his name permanently from such practice. From what? From the role of the state. Removing him permanently. So these are the punishments which can be rendered by the disciplinary committee. Now section 36 of the Disciplinary Advocates Act need to be also seen here. Section 36 is disciplinary power of Bar Council of India. Disciplinary power of Bar Council of India. Please refer to it. Duty of the disciplinary bodies, etc. I may go through it at a glimpse. I may read through the sections. It is read as follows. Where on receipt of a complaint or otherwise the Bar Council of India has reason to believe that any advocate whose name is not entered in the state road has been guilty of the profession or other misconduct, it shall refer to the case to the disposal of it to the disciplinary committee. Now, notwithstanding anything contained in this chapter, the disciplinary committee of the Bar Council of India may either its own motion or on a report by the State Bar Council or an application made to it by the public interested person withdraw the inquiry before it. Disciplinary actions against the advocate may be taken pending before the disciplinary committee of any State Bar Council and dispose of the same. So whatever complaint may be pending before the disciplinary committee of the state can be taken by the Bar Council of India and can also be disposed of accordingly. Now, the disciplinary committee of the Bar Council of India in disposing of any cases under this section shall observe so far as may be the procedures laid down under section 35, which we have seen earlier. Refer the Advocate General in that section C and being concerned to refer to the Advocate General of India. Refer the matter to Advocate General of India also. Now disposing of any proceedings as according to whatever we have seen in section 35. So section 35 is very important. When we refer to section 36, also refer back to 35 of the Advocates Act. Now section 36B, also very important, disposal of the proceedings. So when a complaint is received by the Bar Council and the concerned State Bar Council refers it to the disciplinary committee, it is the duty of the disciplinary committee to dispose of the proceedings before it, dispose of the complaint before it as expeditiously as possible. Now, what is the time period for this? 1 year. Note it down, very important. 1 year. 1 year. So the complaint received by it shall be disposed of as expeditiously and the proceedings shall be concluded within within an year from the date of receipt of the complaint. When year will be calculated? From the date of receipt of the complaint and the date of initiation of the proceedings at the instance of State Bar Council. Whenever the State Bar Council has referred it to the disciplinary committee, from that time it shall be calculated and it shall be disposed of within a year. Now, note it down. P.D. Gupta versus Ramamurthy. P.D. Gupta versus Ramamurthy. P.D. Gupta versus Ramamurthy. 1997, volume 7. 1997, volume 7. SCC 147. So, by this provision, it does not mean that when a complaint is been received by the State Bar Council, the State Bar Council refers that to the disciplinary committee of the state, and the State Bar Council cannot leave it to be decided by the Bar Council of India. Thinking that it will be dealt by the Bar Council of India, it cannot be left as such. It has to be dealt by the State Bar Council's disciplinary committee in accordance to the provisions established under Section 35. Okay, that is what very important. That is what have been dealt by in this particular case. Now, failing such proceedings, 1 year limitation, not limitation actually, it should be finished, disposed of within a year. Limitation is with regarding to the filing of an appeal. We will come across this. So, failing with such a proceeding shall be transferred to the Bar Council. So, if the disciplinary committee is not able to dispose of within a year, the matter shall be transferred to the Bar Council of India, which shall dispose of accordingly. That is what has been stated in section 35B. I will read it. The disciplinary committee of the State Bar Council shall dispose of the complaint received by it under this section 35 expeditiously, and in each case the proceedings shall be concluded within a period of 1 year from the date of receipt of the complaint or the date of initiation of the proceedings at the instance of the State Bar Council, as the case may be. Failing which such a proceedings shall stand transferred to the Bar Council of India, which means if it is not disposed within 1 year, it shall be transferred to the Bar Council of India, which may dispose of the same as if it were a proceedings withdrawn for inquiry under subsection 2 of section 36. It shall be deemed that such a complaint has been withdrawn from the state disciplinary committee and it will be taken to the Bar Council of India. Now, remanding of certain cases by the Bar Council of India to the State Bar Council upon a statutory transfer of proceedings under this section is not permissible. So, remanding it back, Bar Council of India, remanding it to the state concerned bar disciplinary bodies, it is not permissible. Note it down, section 36B, it has been clarified in Arjun Singh Gholi. Arjun Singh Gholi. Arjun Singh. Bar Council of Gujarat. Bar Council of Gujarat. Bar Council of Gujarat. 2017, volume 5, SCC 465. 465. Please note it down. Remanding a case by the Bar Council of India, note it down, BCI, Bar Council of India, to the State Bar Council, upon statutory transfer of a proceeding under this section under this section, section 36B, is not permissible. Is not permissible. Now let us deal with next section, that is section 37, appeal to the Bar Council of India. So whoever is aggrieved by the decisions taken by the State Bar Council's disciplinary committee, what is the option left to you? Naturally, whenever in a case, what happens? You can file an appeal. So appeal to the Bar Council of India is what is dealt in section 37. Any person aggrieved by an order of the disciplinary committee of the State Bar Council made under section 35, now may within 60 days, not at all, 60 days of the day of communication of the order to him, prefer an appeal to the Bar Council of India. So the limitation period preferred here in under section 37 is 60 days. Every such appeal shall be heard by the disciplinary committee of Bar Council of India, which may pass such order, including an order varying the punishment awarded by the disciplinary committee of the State Bar Council thereon as it deemed fit. So the Bar Council can vary from the decision rendered by the State Disciplinary Committee. Any person, that is an advocate, any person, it is herein mentioned as any person. We can, it is a wider terminology used here. Any person aggrieved by the decision of the State Bar Council. Aggrieved by the decision of the State Bar Council. So the Bar Council's State Bar Council is also one among them who can be an aggrieved person. Can't it be? State Bar Council itself can be an aggrieved person. So State Bar Council itself can file an appeal against the decision rendered by the Bar Council of India to the Supreme Court. That is another section. So any person who is aggrieved by the decision of the State Bar Council can prefer an appeal against the decision rendered by the disciplinary committee of the State Bar Council to the Bar Council of India. And the Bar Council of, this should be done within how many days? 60 days. 60 days from the date the decision has been communicated to that particular person against whom that decision has been verdicted. 60 days from the communication of the order to that particular person. An appeal can be preferred by him to the Bar Council of India against the orders rendered by the disciplinary committee of the State Bar Council. Limitation period is 60 days. So the Limitation Act of 1963 is applicable to this appeal. Okay. Limitation Act of 1963, which you have studied in CPC, Civil Procedure Code. It is also applicable in the Advocates of 1961. Now refer to case law, write it down. I will simply tell you the citation. 2012 volume 1, 2012 volume 1, SCC 741, 2012 volume 1, SCC 741, which clarifies that Limitation Act is also applicable to Advocates Act of 1961. Now, if the Bar Council of India is taking a decision which is varying the decision of the State Bar Council, an opportunity should be given to the other person, that is here in the complainant who has given the complaint. The complaint may be given by the Bar Council itself. It itself can be a party and it itself can take an action, initiate an action against that particular advocate, which it feels that he has done, which is against the professional misconduct. So at any point of time should be given equal opportunity, an opportunity of being heard, responded, that is natural justice has to be followed there. So whenever the Bar Council is varying its decision, varying the decision which is rendered by whom? The State Bar Council, the Bar Council of India should give an equal opportunity to the other party to be heard. That is also very important, which is seen in section 37 of the Advocates Act. Now let us deal with section 38. It is none other than appeal to the Supreme Court. So again, the advocate against whom the state disciplinary committee has rendered an action or verdicted against him, he appeals to the Bar Council of India. Now the Bar Council of India also finds it to be correct. The decision rendered by the disciplinary committee is found correct by the Bar Council of India. Now here again, the advocate concerned is given an opportunity to appeal before the Supreme Court. Section 38. Any person aggrieved by the order made by the disciplinary committee of the Bar Council of India under section 36 or section 37 may within 60 days, again limitation here is 60 days of the date on which the order is communicated to him, prefer an appeal to the Supreme Court, and the Supreme Court may pass such order, including any order varying the punishment awarded by the disciplinary committee of the Bar Council of India thereon as it deemed fit. So again, here also that particular proviso which we have seen in section 37 can also be seen. When the Supreme Court is varying the decision of the Bar Council of India, equal opportunity should be given to be heard to the other party. Proviso is there. Now here also limitation period is 60 days and the Supreme Court can take an action or it can hear an appeal. Now it is not in conflict with the subclause 1 Article 138 of the Constitution. Article 138, it's not against. It is coping with. So that is also to be addressed here. Aggrieved by the decision of, as we have seen in section 36 or section 37, he can prefer an appeal before the Supreme Court concerned within how many period? 60 days. And equal proviso says that, proviso says that opportunity to the other party should be given if the decision varies. If I am going to set him free, set that particular advocate free, then in such case it has to be given an opportunity to the others. Supreme Court may pass any such order as it deems fit. Appeal to the Supreme Court is not a restricted appeal. Question of law is what need to be addressed therein in the Supreme Court. No, it is not limited to that. This appeal is not limited to question of law alone, but also the question of fact. In such case, this is a particular exception. So write it down. N.O. Mohindro, M-O-H-I-N-D-R-O-O, N-O-N, sorry, O-N Mohindro, O-N, initial ana, O-N Mohindro, M-O-H-I-N-D-R-O-O versus District Judge Delhi, District Judge Delhi, 1971, volume 3 SEC, page number 5. The Supreme Court, write it down, Supreme Court do not act, A-C-T, act wrongly, do not act wrongly if they entertain subsequent petition from a person whose case has been dealt with the disciplinary committee. Full stop. This appeal is not a restricted appeal. This appeal is not a restricted appeal. It is an appeal on fact as well. It is an appeal on fact, fact as well. It's not only an appeal on law, but it's also an appeal on fact as well. Now, section 40 of the Advocates Act. Stay of order. So, Bar Council of the Disciplinary Committee of the state may have verdicted for the suspension or removal of your name from the roll. Now, can you practice? You cannot practice before any court. You cannot appear before any bench, any tribunal, any person. Now you are preferring an appeal before the Bar Council of India, or the other way. The Bar Council of India may have verdicted, taken a decision whereby suspending you or terminating your name from the roll. Then you cannot practice, and you are preferring an appeal before the Supreme Court. You are filing an appeal before the Supreme Court. When you are filing an appeal before such Supreme Court, again there will be a restricted time frame within which the matter shall be disposed of. Maybe 1 year, as we have seen, 1 year. Now with this 1 year, are you allowed to practice? No, you are not. Now you will prefer an order to be passed by the court, the Bar Council of Supreme Court, under section 40, to stay the order of the disciplinary committee. That is dealt under section 40 of the Advocates Act. Stay of order. An appeal made under section 37 or 38 shall not operate as a stay of the order appealed against, generally, against. But the disciplinary committee of the Bar Council of India or the Supreme Court, as the case may be, may, it is not always, may presumption, for sufficient causes, direct the stay of such order on such terms and conditions as it may deem fit. So, the Supreme Court or the Bar Council of India is vested with the power on certain conditions, considering the matter before it, it may order for a stay, whereby the order made by the disciplinary committee or the Bar Council of India will be stayed unless until further finally verdicted by the, found him guilty by the concerned court, that is the Supreme Court or Bar Council of India. That is with regard to section 40 of the Advocates Act. Where any application is made for stay of order before the expiry of the time allowed for appeal. Therefore, under section 37 or 38, the disciplinary committee of the State Bar Council or the disciplinary committee of the Bar Council of India, as the case may be, may for sufficient cause direct stay of such order of such terms and conditions as may be deemed fit. That is with regard to section 40 of the Advocates Act. Now we have to refer to again section 42, the powers of the disciplinary committee. These are all part B questions. Okay, these are all part B questions. To whom we shall be an appeal shall be filed? What are the proceedings of appeal provision? What are the limitation of appeal? Now, in an appeal preferred, can an advocate practice in between? That is the stay of, with regard to stay order. What are the powers possessed by the advocate? Disciplinary committee, etc. All comes within the purview of part B questions. And part C question is nothing other than what we seen in the, from what itself is an instance of professional misconduct. They will ask you each instance of professional misconduct, whether this comes within the X or Y act done by the advocate comes within the purview of professional misconduct. Thank you. You may go for a break. And please, tomorrow it's a holiday. We don't have, neither we have court visit, neither we have classes. Okay, tomorrow, only for tomorrow.
Yes, please. Right. Yeah. You know, you know the meaning of a handicap. என்ன ஹேண்டிகேப் அண்ணா கையில் அண்ணா ஹேண்டிகேப்பு காலின் நல்ல ஹேண்டிகேப் புரிஞ்சுதா can you live the life with some infirmity in your body no using mobile phones in the classroom is again a handicap for you whoever is using the mobile phone my question is yeah please my question is why you can't leave the mobile you can leave your wife also no problem but you don't leave your mobile phones huh you will leave everything your wife your child including your entire life also you leave for mobile phone then you don't marry keep the mobile phone with you huh that is enough for you she is a time pass for you mobile phone time pass everything no why last bench this is the profession which is self-regulated profession ஒரு மாட்டு கிளாஸுக்கு வந்தாவிட்டு you have the minimum things to follow in the class to see we are not here for our sake you know how I am going to teach you every day I am spending so much of hours reading and coming here making a structural framework in my mind some respect you give some professors some respect if you don't give you know there is one law is there not this law universal law next time when you got marriage and if you got the children they will do the same thing to you நீ எனக்கு ரெஸ்பெக்ட் கொடுத்தாலும் கொடுக்கா போனாலும் பரவாயில்ல ஏன் எனக்கு தேவையில்லை it's a profession you how can you expect you don't to be in discipline you are expecting your children to be in discipline ஆமாவா இல்லையா நீங்க மார்னிங் 3 மணிக்கு எழுந்து படிக்க மாட்டாங்க நாளைக்கு உங்களுக்கு மேரேஜ் ஆச்சுன்னா பையனை பொண்ணை 3 மணிக்கு எழுப்புங்க எழுந்து படின்னு சொல்லி you are doing injustice to you please whenever comes to the class first thing is listen I already told every day is a learning day ஏதாவது மைண்ட்ல போட்டுக்கோங்க please incorporate something in your minds it's a fag end of your thing every day if you are not interested again listening is your fundamental right not listening is also your fundamental right but there is one dash is there subject to reasonable restriction if you are not interested you can keep quiet without disturbing the others no something you follow in your life then only you can reach the greatest heights in your life you see நான் வந்து ஒரு 5-6 years முன்ன நான் ஒண்ணுமே கிடையாது. I have followed certain things in my life. Now I am before you. I request you, if you are not able to understand or if you are not interested, please stay quiet. Please stay quiet. Don't outrageous professors. They are all preparing a lot and coming before you. Right? புரிஞ்சுதா? You are all good children. Basically good children. But you have certain things in your mind. If you eliminate those things, you are all good children. புரிஞ்சுதா? Please listen. Right? Now we have seen. Oh, right. Why you are laughing? You know who is she? Huh? Yara. She is my wife. Right. Yeah, please. She maintains silence here. She maintains silence. My also in my home. Oh. Right. No. It's a satirical sense. You are all now sitting here. Yeah, please. Now, ஏன் joke போட்டேன்னா, I know. Sitting here, again taking something, coming there, sun is there, so much of things in your life. But in some sense, life எப்பவுமே என்ஜாய் பண்ணணும். எப்படி என்ஜாய் பண்ணணும்? பாசிட்டிவ் சென்ஸ்ல என்ஜாய் பண்ணணும். புரிஞ்சுதா? ரைட். Now, கிளாஸுக்கு போலாமா? Will you listen? Good. Right. Now, சசிகலா, ஓகேவா? Right. சசிகலா அந்த சசிகலா இல்ல, ஸ்டூடெண்ட் சசிகலா எங்க? Right. Now, right. You are all basically good. I know you. Please keep quiet. Listen something. ஏதாவது கேளுங்க மைண்ட்ல. Just listen something. Don't open your phones. அப்புறம் பண்ணலாம். Right. Now, we have seen, come to the fag end of arbitration. We have seen commencement of arbitration, different types of arbitration, how an award has been passed, then different types of awards we have seen, how to challenge the award under section 34 of the arbitration conciliation that we have seen. Now, the biggest part is foreign awards. Today we are going to see foreign awards. You know, two types of arbitration is there. Number one is domestic arbitration. Second one is international commercial arbitration. Right. Now, assume that an award has been passed outside India. Two countries are there. Two countries இருக்கு. India ஒரு company இருக்கு, அமெரிக்கால ஒரு company இருக்கு. Now, dispute arises between outside India and award has been passed outside India. Now, that award is known as foreign award. Now, if you see the CPC, you are having foreign judgments. Enforcement of foreign judgments. Irukka CPC la? Have you turned out the CPC? Sir, paathirukom, adu enna theriyadu. Right. Now, CPC contains the mandate for enforcement of foreign judgments. Right. Now, for enforcement of foreign awards, Arbitration Conciliation Act 1996 contains provisions. You understand? CPC speaks about foreign judgments. Why CPC speaks about foreign judgment? That's the difference between judgment and award. You understand? Judgment is passed by the state power. That means state exercising judicial power. That's why CPC contains provision. Now, award has been passed by whom? Private adjudicatory persons. Now, that means CPC don't have provisions respect to enforceability of awards. Now, the Arbitration Conciliation Act contains how to enforce the foreign award plus how to challenge the foreign awards. Right. Now, the entire arbitration proceedings, if you take entire arbitration proceedings, we can analyze by way of 4 steps. First one is commencement of the arbitration. Right. How you are going to commence the arbitration? By entering into an agreement. Right. Once you enter into the agreement, deciding upon the arbitration, second step is how to conduct the arbitration. Right. Second step, how to conduct the arbitration. You know why? Normally, courts are bound by law. Here, arbitration is not bound by law. You yourselves will regulate how to conduct the proceedings of the arbitral tribunal. Second step. Third one is challenging the award. Right. This is third step. Third stage. You can speak it. Now, coming to fourth stage, if you challenge different aspect, if you don't challenge, next one is enforceability and recognition of the award. This is the fourth stage. Enforceability and recognition of the award. If you are not challenging the award under section 34, now it has to be enforced. Right. Now, you are going to recognize the award. You are going to recognize the award. Once you recognize the award, then you are going to enforce. You understand? Now, the entire premise is you can recognize law. Now, when an award has been passed by a person outside the ambit of the courts, how you are going to recognize this? This is the question. You understand the question? Courts will pass so many things. You are bound by the courts. Award has been passed by whom? A private person. Right. When a private adjudicatory person who is not having the force of law, when he passes an award, how you are going to recognize that award, that to foreign award, the award that has been passed outside the India, then recognizing is one aspect and enforcement is another aspect. Now, if you recognize the award, that itself does not come into enforcement. Simply you are recognizing the award. Yes, award is there. Now coming to second thing, enforcement is another step. If you don't recognize, enforcement will comes into picture. You understand? Enforcement is a legal process, judicial process by which an award that has been recognized is judicially enforced by the courts. That means a private act is confirmed by the state act. You understand? Public act. A private act means arbitrator. That is being confirmed by whom? By the public act, that is judgment of the court. Right. Now, to recognize these acts, before enactment of the Arbitration Conciliation Act 1996, you understand? Before which act speaks about Arbitration Conciliation? Act 1996, previously 1940 that has been repealed. Now, this 1940 Act does not speaks about recognition of foreign awards first thing. Right. Now, there is one separate act is there, Foreign Awards Recognition and Enforcement Act. Foreign Awards Recognition and Enforcement Act. Right. Now, this act has been repealed by Arbitration Conciliation Act 1996. Now, let us see the difference between Foreign Awards Recognition Enforcement Act and Arbitration Conciliation Act 1996. Under the old act, that means Foreign Awards Enforcement and Recognition Act, what happens when an award has been passed by a foreign country or whatever it may be? You have to come to the court, then you have to present the award to the court, based upon that award, court will pronounce a judgment. Unless and until court pronounce a judgment, award is nothing but decree. Decree. Under the old act, what happens? You have to take the award, go on, what is called file the award in the courts, then court will pronounce the judgment. Right, then only award assumes the character of enforcement. Right, now that is old act, it has been repealed now. Now coming to new act, the new act simply says within 30 days of passing the award, and if it is not challenged, it is nothing but a deemed decree, straight away courts can enforce it. You understand? Previous case la enna pannanom, award eduthu poi court la poi file pannanom award file panna vittu da court வந்து என்ன பண்ணும், அந்த award மேல judgment decree கொடுக்கும் திருப்பியும், then only it becomes a decree. New act la enna நடந்தது, நீ ஒன்னும் கோர்ட்டுக்கு போற தேவையில்லை, 30 days குள்ள நீ award challenge பண்ணலன்னா that is nothing but a deemed decree under section 36 of CPC. You understand? Now this is the procedure. Now you are not in India, that means award has not passed in India, that means some foreign country has passed the award. Now whether you want to enforce this award, first thing is, that is, this is the contracting state of that state. You understand? And the award நீங்க recognize பண்ணனும்னா arbitration conciliation act kiya provisions kadiyadu. It's international commercial arbitration. Remember, award has been passed under the gambit of international commercial arbitration. If you want to recognize that award, there should be some treaty between you and that country. You understand? There should be some treaty between you and that country. Unless and until you are signatories to that treaty, you are not bound by the award. You need not enforce and recognize the awards. Right. Now, our entire act has been based on what? UN Citral model. Right. That means we are signatories to that treaty or convention. That means I will enforce your award, you will enforce our award. America award pass panna, நாங்க enforce பண்றோம், நாங்க recognize பண்றோம். நாங்க award pass பண்ணா, நீங்க enforce பண்ணுங்க, நீங்க recognize பண்ணுங்க. அது எப்படி வரும்? ரெண்டு பேரும் மியூச்சுவல்ல போய் சைன் வச்சாதான் வரும். You understand? எதுல சைன் வச்சா நம்போ? Again, two conventions are there. Geneva Convention is there, New York Convention is there. Right. Now, New York Convention, this is contained in chapter 1. Chapter 1. And this Geneva Convention is chapter 2. Now, you are signatories to both the convention. Again, because of that convention only you are recognizing this award. You understand? Not because of any indigenous act. Right. Now, you are telling, I will ask you one question. Simply by signatories to that convention, whether award that has been passed outside India, can you accept that award? Means yes, by signing that convention, the central government has published the same that we are going to bound and we are going to recognize that award in the official gazette. By that way, we are giving what? Legal sanctity. You understand? So yes, we are signatories to that things. Now we are treating that award as enforceable, that has been published in the official gazette. Now, basically, you can recognize the foreign awards either under New York Convention or Geneva Convention. Option is up to you. But normally, New York Convention is widely acceptable by all the states. In fact, it is called as it is the edifice on which the entire international commercial arbitration lies. What is the meaning of edifice? It's a stage. It's the arena on which entire commercial arbitration lies. Now, you know, everything, it cannot go for arbitration. Arbitrable. Only arbitrable cases can go for arbitration. Matrimonial disputes cannot go for arbitration. Right? Matrimonial disputes, arbitration povacha. Prema povacha. Fraud povacha. Insolvency povacha. Consumer disputes povacha. No. Nen povacha. Right. Right. Now you have understood two aspects. One is earlier act, you have to file in the court, get a decree. Under the new act, it is not the same. It's a deemed decree. Now, how you are going to recognize the foreign awards when you are signatories? Two conventions are there. You have signed those conventions, you have published in the official gazette. Right. Now you understood. Now let us go into definition of foreign award. So foreign award ante enti. Now section 44 speaks about foreign awards. Section 44 of Arbitration Conciliation Act speaks about foreign awards. Now, unless and until you understand the definition, you cannot what is called go into the veracity of the meaning. First thing is, the foreign award, it is an award arising out of arbitration agreement dealing with the differences between the persons, whether arising out of contractual terms or not. It's nothing but an agreement arising out of differences that has been entered into between the two persons, whether that agreement may be a contractual agreement or not. First thing. Second thing is, it is considered as commercial in law in force in India. Whatever be the subject matter you are entering into arbitration, that should be commercial. You understand this term, commercial. Commercial enna. That means, for example, here distinction has to be drawn. Commercial means buying and selling of goods. Right. Buying and selling of goods. Now, a case has come before the Supreme Court. Whether commercial includes service agreements also. In service, you are not doing anything. There is no purchase and sale. You are telling that it is commercial, considered as commercial in law in force. That means it should be commercial that has been recognized by the respective laws. Right. What is commercial means? Then Supreme Court said even service agreements also come under commercial aspects, even though it don't have any sale and purchase. So many transactions has been considered as commercial, and the transaction commercial anada arbitration ku pono illana po mudiyadu. Right. For example, factoring services are there. Factoring services, brokerage services, so many services. Now I am not going into those aspects. Factoring is a banking law, right? So many services. This is second aspect. First aspect, it should be a what is the arbitration agreement dealing with differences between two persons, whether contractual or not. Then it should be a commercial in law. Third aspect is the award must have been made in pursuance of an arbitration agreement. This is third thing. Award must have been made in pursuance of an arbitration agreement. The fourth one is award must be made in one of the reciprocating territories. Now you understand. Reciprocating territories means who are signatories to New York Convention or Geneva Convention. Award has been recognized or passed in one of the reciprocating territories, now declared by the central government by notification in the official gazette. ஏதாவது புரிஞ்சுதா? புரிஞ்சுதா இல்லையா? புரிஞ்சுதான்னாலும் கொஸ்டின் கேட்பேன், புரியலன்னாலும் கொஸ்டின் கேட்பேன். எப்படி வசதி? என்ன சினிமா எல்லாம் பார்த்து மோட்டிவேட் ஆகாதங்க, அதெல்லாம் சினிமா. என்ன பார்த்து மோட்டிவேட் ஆகுங்க. ஏன்? ரைட், நவ் யூ ஆர் குட் சில்ட்ரன். எஸ், யூ ஆர் லிசனிங், and if you are not interested, you are not listening. Everything is acceptable. Right, now you understood reciprocating territories. Now this convention says you need not recognize our awards. You need not recognize our awards. Now we have given one thing, that is reservations. Reservations means it's a reciprocity reservations. అంటే మీకు ఒక ఆప్షన్ ఇస్తాం. We are going to give you one option whether you are going to accept that award or not. Two reservations are there. Now the India is signatory to that bilateral treaties. India is also having two reservations, reciprocating reservations. Now this has been on the doctrine of universality. మీరు మా అవార్డుని మీరు రికగ్నైజ్ చేసి ఎన్ఫోర్స్ చేస్తే మీ అవార్డుని మేము చేస్తాం. ఫర్ ఎగ్జాంపుల్, extradition treaties are there. Extradition treaties, for example, if any person does any crime in India, he goes to some other country, unless and until you are signatory to the treaty, they don't send that person to. That is the problem we are facing now. Neeraj Modi, Vijay Mallya, they are there. They are not sending those persons. ஏன் அவங்க அனுப்பலன்னா நம்மளுக்கு அவங்களுக்கு ட்ரீட்டிஸ் கிடையாதுன்னா you are not bound by the same. Now two reservations have been given. One is foreign award can be recognized as a commercial under the law in force that has been made after 11th October 1960. 11th October 1960, after all the awards, it should be made. First reservation. Second reservation is the award should be made in one of the territories by virtue of which central government by notification in the official gazette declared to be territories to which this convention applies. Right. అండర్స్టాండ్? అర్థం కాలేదా? కాకపోతే మళ్ళీ చెప్తాం, నో ఇష్యూస్. నా అంటే అవార్డుని మీరు ఫాలో చేయాలి అంటే మీరు చేయాల్సిన అవసరం అయితే లేదు. ఫస్ట్ ఎప్పుడు ఫాలో చేయాలి అంటే మీరు ఆ న్యూయార్క్ కన్వెన్షన్ కానీ జెనీవా కన్వెన్షన్ కానీ సైన్ పెడతారు. ఎందుకు సైన్ పెడతారు? మీరు పాస్ చేసిన అవార్డు మేము ఎన్ఫోర్స్ చేస్తాం, మేము పాస్ చేసిన అవార్డు మీరు ఎన్ఫోర్స్ చేయండి. సైన్ పెట్టిన తర్వాత ఆప్షన్ మీకు ఇస్తారు. ఇప్పుడు మీరు ఫాలో చేయాలి అవార్డు అనుకోండి, స్ట్రైట్ అవే యూ కెనాట్ ఫాలో. మీరు ఏం చేస్తారంటే ఆ టెరిటరీ దట్ హాస్ బీన్ ఇంక్లూడెడ్ ఇన్ ది అఫీషియల్ గెజిట్, ఏ కాంట్రాక్టింగ్ స్టేట్ లో అవార్డు పాస్ అయిందో ఆ స్టేట్ ని మేము రికగ్నైజ్ చేస్తాము అని చెప్పి ఒక నోటిఫికేషన్ ఇష్యూ చేయాలి. ఇష్యూ చేస్తే ఏమవుతుంది? మేము బై నోటిఫికేషన్ అగైన్ అడ్మినిస్ట్రేటివ్ లా ఇన్క్లూడ్స్. గుర్తుందా? ఏం లా ఇన్క్లూడ్స్? వెరీ గుడ్. ఆర్డర్స్, రూల్స్, నోటిఫికేషన్స్, ఎవ్రీథింగ్. అగైన్ నోటిఫికేషన్ ఈస్ ఏ లా. యూ క్యాన్ ఛాలెంజ్ దిస్ నోటిఫికేషన్ ఆల్సో. రైట్, అగైన్ లా. అంటే నోటిఫికేషన్ ఇష్యూ చేయడం అనేది ఏం నథింగ్ బట్ law only. This is one aspect. Now, how to what is called enforce the award, prerequisites for enforcement. You are going to the courts and you want to enforce this award. Prerequisites. First one is the original award or a copy duly authenticated by the law of the country in which it has been made. మీరు ఏం చేయాలి అంటే ఒరిజినల్ అవార్డ్ పాస్ చేస్తారు చూసారా, you have to take that copy or authenticated copy of that award you have to take. Second one is original agreement for arbitration or a duly certified copy thereof. You have to have second thing. Third one is you have to prove by way of evidence that it is a foreign award. Right. Now, previously, the jurisdiction for enforcement of foreign awards is Principal Court of Civil Jurisdiction. Right. Now, after the Amendment Act, now it has been shifted to High Court having original civil jurisdiction. High Court should have civil jurisdiction. Right. Now, these are the prerequisites for enforcement of the award. Again, simply here also you can challenge the award also. There is provision is there. Now, award is there. Assume that everything is fine. The courts will enforce the award. Now, if you want to challenge the award, section 48 speaks about. Section 48 speaks about. Right. Now, let us venture into the grounds on which you can challenge the foreign award. Foreign judgment is different, foreign award is different. Judgment has been passed by the courts, award has been passed by the private persons. You have to understand the difference. You are giving some legal sanction. Why? You are seeking enforcement means, normally you know, whenever a decree has been passed, if it has been obeyed, you need not go for execution. Here also, the person who is not obeying the award is known as award debtor. Award debtor. Now, he is not obeying the award passed by the persons. Then, with the help of the state means here court, with the help of the court, and court by virtue of the exercise of the powers, it will impose certain legal sanctions on you. What is meant by legal sanction? Legal sanction, jurisprudence. என்ன jurisprudence அண்ணா? அது ஒரு சப்ஜெக்ட் தேர்ட் செம்ல. ஏன் உத்தேஷ்? ஏன் jurisprudence అంటే லீகல் சாங்ஷன். ரைட். லீகல் சாங்ஷன் என்னன்னா லீவ் சாங்ஷன் பண்றது கிடையாது, பனிஷ்மெண்ட் சொல்லுவாங்க லீகல் சாங்ஷன்ஸ். நவ enforcement, how the courts are going to do by having certain legal sanction. That means if you don't obey the award, court has powers to attach your property. That is a legal sanction. Attach your property. Freezing your bank account. It is a legal sanction. It's a punishment. Freezing your bank accounts. Even in extreme cases, putting you in custodial sentences also. జైల్లో కూడా పెట్టి మిమ్మల్ని చేయొచ్చు. పురుంజిదా? Right. Now, this is enforceability. Under which section you are going to challenge? Section 48. Good. Again, 48 contains some grounds. Now, whenever you are going and challenging the same, the the ground should be mentioned in the act. Why? Very, very limited exceptions has been given. You understand? Limited exceptions to challenge the award. Right. If you have more exceptions, there is no need for going for arbitration awards. What is meant by arbitration? It is nothing but a voluntary acceptance on your part that the award should be final and binding on you, or voluntarily accepting. You understand? Now, if I put more exceptions, the exceptions means the grounds on which you are going to challenge, then what happens? The very thing on which the premise lies has been destroyed. Right? Arbitration ki meaning lekunda potundi enni grounds and anni grounds. Now, arbitration can be whether it is a domestic award or it is a foreign award. The grounds is having very, very limited. Apart from these grounds, without resorting to these grounds, any award, anything can be set aside on the basis of public policy. Understand? Without resorting to these things, if the court finds that the award has been made in contrast to public policy of India, then it can set aside the award that has not been in the grounds enumerated in section 48. 48 ground only the maximum court has to take. But public policy is a wider terminology that may include so many things. Understand? We'll see tomorrow the grounds on which you are going to challenge section 44. You got something today? Right. Thanks for being silent. More thanks. Either claps. Now, fourth claps. Claps. Right. Class out. Enjoy class. Some positive sense. Right. Have a good day. Right.
Good morning, guys. So, how are you? Good. Crimes done. Now come for the punishment. So, today's topic is penology. As criminology, study of crime. Penology, punishments. So, actually this penology has consist of two words. One is peno, or some words it's pena, and or pano. Greek, Latin and French word, which means punishment or penalty. Another one is logi. It is come from a Greek suffix logia, which means of study. So, as you says, penology means study of crime. Sorry, punishments or penalties. So, this punishment or penalty is with us since when? Since the crime is with us. So, before this Homo sapiens, we are Homo sapiens. Prior to us, Homo nomadics, then other things are there. Those who lives in the jungle, or they are not group themselves or don't make the society. Does the crime and penalty or punishment comes from them, or it is with us since them? Yes, because at that time the rule of survival is what? Survival of the fittest, or the jungle rule. That means for food you can do anything. So there it creates a crime. That means if I collect my food and for food someone other snatch it, then it creates a crime. So to stop that crime, punishment was there. So how that society develop our criminal system and our penal system also develop. That means for every new crime, we, or to stop it, we impose a penalty or punishment. So now, what is the definition of crime? Sorry, punishment or penology. As you says, penology is the study of punishment. Does it only study of punishment? Yes, it is not only the study of punishment, it also the study of the reformation also. That means imprisonment, prison, everything, whatever comes in the form of reformation. So this study of penology does not only say that what is the amount of punishment or when that punishment is to be given, but it also included why that punishment should be given to you. That is the study of penology. So if we go to some jurists, let the Francis Lever, the father of penology, he says that penology is a branch of criminal science which occupies itself or to do so with the punishment of the criminals. That means what you have to be done if you don't do it, or when you don't have to do anything, when you do it, and the punishment or the fine or penalty imposed upon you, that is the penology. After that, some more penologists or the jurists come who enhance the purview of the penology. Not only they concentrate on the study of that penalty punishment, they also start to study, as we said, the reformation, or they also look for the reformation side of the society also. Yes or no? So we can say penology, or we can say that silent. What are the silent features of the penology? First, it is the technique for the punishment, so also the technique for reformation of the society. That means it is not only check the crimes, but also those who conduct it or who commit it, to check them also. It is also a constructive reformation or constructive way. It will maintain the peace in the society by reforming the criminals. So basically, it is this penology is a collective formulation of theories where it try to, or it corrects and checks the criminal behavior of the society. That is our penology. So why we should read this penology, or is it essential for us to study the penology? Yes. Why? To check the crime. Criminology, if criminology is there, then next part is your penology. Unless until there is a crime, you cannot impose a penalty over them. Few decades before, sati pratha is a virtuous thing. When you make it criminal, you have to impose a punishment for it. Prior to some years back, triple talaq is good thing. But yes, according to that Muslim law, talaq-e-biddat, what is known as triple talaq, is a sinful thing. But still, it is goes on in our society, and it is a good thing. But after Prevention of Triple Talaq Act, it become a crime. You have to give a punishment for that, whoever do that thing. Some years back, or after the amendment of 2019 MV Act, pillion rider need not to wear a helmet. But now you have to. But most of us don't wear, while we're driving the bikes, we don't wear that helmets. So my point is, when we make, or society makes an act as a crime, we need a punishment for that thing. We cannot only say that this act is crime and you have to stop it. No, you have to impose a fine or penalty over that. So that's why we need to study the penology, or in other words, we can say that this is the relation between your penology and criminology. Without criminology, there is no penology. Without penology, there is no criminology. So we have to go a little bit in our history. When, as we have already discussed, that from when it is started from when we have start to live in a group, from the time of Homo nomadics. After Homo nomadics, there is Homo sapiens, early Homo sapiens, or later part of the Homo nomadics, we started to be in the group. And while we started to be in a group or in society, the crime is with us. And when there is crime, penalty is also with that. If we concentrate on India, the right to give punishment is only with the king. That's why he known as Dharma Danda Chhatradhari. Danda means the power to punish. Chhatra means those who has the power to protect. That's why Shivaji Maharaj, also known as Chhatrapati Shivaji Maharaj. So the power to give punishment or to protect someone is with the king. That's why Dharma Rakhyati Rakhyata. Those who protect the Dharma, it is Dharma protects him. And what is Dharma? Jad Harayati Sadharma. It is the duty of the king to protect his subjects. And till now, it is continuing. Because nowadays, it is the duty of the state to protect its subject, or the punishment, power of punishment is also with the hand of the subject, not with us. So from this thing, we can say that in ancient time or still now also, 5 type of theories by giving the punishment is continuing. In IPC, everyone under section 53, the types of punishment. We have already discussed that about the theories of punishment also. So now, what is the theories of punishment? Can anybody say me? What are how many types of theories are there? 5. What are they? Retributive, preventive, deterrent, expiatory, reformative. Yes. Now come to one by one. What is reformative? Yes, basically to return back. Revenge theory or return back theory. What you have done to me, I have to do it same thing with you. So eye for an eye, tooth for an tooth is the basic principle of this retributive theory. So if you can, so retributive theory or vengeance, theory of vengeance, it is the ancient or most ancient theory. One of this theory is retributive theory. That means, as I told you, survival of the fittest. How you can survive? By killing other. And if you kill me, I have to kill you, or some of my family has to kill you. That is the theory, retributive theory. But it has a problem, or we can say that it has the criticism. Because if you go through that a quotation of Mahatma Gandhi, eye for an eye, make the whole world blind. But ironically, in none of this quotation mentioned in the Mahatma Gandhi's book, or there is no records that Mahatma Gandhi said these things. It is that in the film Gandhi, that actor, I don't recollect his name, it is his dialogue that when eye for an eye makes whole world blind. But originally there is no records that Mahatma Gandhi has said these words. Okay, whatever it is. So why jurists criticize these things? For us, till now also, some countries follow this theory, theory of vengeance. If you go to the Saudi countries, they are still following these things, that whatever is done with you, same thing is done to you also. But why? It is some point of time, it is looks that it is good theory. But why it is criticized? Because it start a chain of vengeance. You kill me, some of my family member kills you, then some of your family member kills that family member. So it creates a chain, and it is not the proper way to punish someone. Yes or no? So this theory forgets the main principle of the punishment. What is the main principle of punishment? To check the crime, not to start a new crime, or to reform the society from committing that crime, not to make another crime. That's why this thing was criticized. Next theory is our deterrent theory. What do you mean by deterrent theory? To deter someone to commit that crime. Yes or no? By how? How you can deter him from committing that crime? By imposing punishment him. Yes or no? So by that punishment, that society get a message that if you do same thing, the same result is going to happen with you. Public executions, that in still in Saudi Arabia, I think they publicly execute those who makes any offense against state, rape, or any other heinous crimes, where they bring you to a square and shoot you. That is the deterrent theory, that from your result other get the a lesson that if you do that thing, you get a same type of punishment. So in deterrent theory also, what they did, they isolate that person from the society, like imprisonment. And that is the point where it is criticized. If you don't give a person to change or reform and you send him to a imprisonment or give someone a punishment like public execution or public beating, what is the changes brings to that person? Okay, this is the result. No, we'll do it because your mind or that person's mind accept that thing, that yes, if I am going to do this thing, I get only this type of punishment. They kill me, okay, I have to kill you. They do a public beating with me. So that is the point where they start to criticize it, because it does not check that person from further or deter that person from further committing that offense, but it makes him harden to make some more crimes. That is his criticism. Next one, preventive. As like it is in deterrent theory, we have that state has to deter that person from committing another offense, or that type of offense is not committed further. That is the main objective of the deterrent theory. Now in this preventive theory, the person should be prevented from committing offense, similar type of offense. You steal something, your hand was cut off. You speak something against the state, your tongue was cut down, so you cannot further speak a similar word. That is the preventive theory. That means next time you can't do that similar type of offense. So this Mr. Kant or jurist Kant is the main criticizer of this type of theory of punishment. He says that this theory treats human as a thing. That means those who commit the crime, in this case, they don't give him a chance to reform or give him a chance to repent for that thing. You directly treat him as a thing, like we did with our food. If this portion is bad, just carve it out, eat the rest part. If this thing is become bad, just replace that thing. We do same thing with the things, and this theory says that same thing. This hand makes you to commit a crime, just cut it. So that is the point of criticism for this theory. Now, next one is expiatory theory. So, this expiatory theory has the two connotations. One is positive connotation, another is negative connotation. In negative connotation, the state makes you, or the society makes you to repent for that thing by imposing fine on you, or imposing certain charges on you, or send you to the jail, where you can repent for that thing what you have done it. In positive connotation, when by your guilt, sometimes we do something and we have a guilt for that thing, that is your repent, or it is the expiatory theory, when you repent for your crimes and the victim माफ कर दिया चलो, that is the expiatory theory. So sometimes it is criticized for its that part where the criminal was made to repent for his crime. Here you are compelling someone to accepting his crime and to repent for that thing. This is the criticism for this theory. Another part, when that victim, when the offender repent by himself, or he has a guilt that no, what I am did is a wrong thing, and the victim, okay, make him okay, chalo maaf kar diya tumhe. So some criminals, what they did, they take the advantage of this. If that victim was a good person and साहब माफ कर दो गलती हो गया, and victim says like okay go. So in this point, so because one part which is becomes more stringent and other part becomes more lenient for this expiatory theory, that is the criticism for this point. Now the recent one and the last one also, the reformative theory. What is reformative theory? When one has given a chance to reform himself. What is the main purpose of our penology or punishment system? So basically this reformative reformative theory is not the recent one, but also the ancient one, if we can say, and recently it is added to our penal provision, where the persons are given a chance to reform themselves. How ancient one? Because when that is time when the kings, queens are there or rule over the society, when they admit that this person has a repent for his war, they give forgiveness for that person. Okay, you are reformed from your soul, so let him free. Now, how it is reformed? How a criminal is reformed today? By giving them education, by giving them work, or by giving them training, how they can adjust with the society once they come out from that imprisonment. That's why they learn how to plumbing, how to do that carpenter's job. All that things they are learned there. That's why once they can come out, they can mingle with that society, or they can earn their livings there. That is a type of reformation, brings a reformation inside you. That open jail theory, what is it? It gives you a chance to reform yourself inside that custody. That is the reformative theory. So whenever your question comes, and it is a very important, not only in that IPC but also here also, what are the theories of crime? Theories of, sorry, punishment. So that this 5 theories you have to write down, and the criticism, why that theory was criticized, that thing also you have to mention in your answer script. So for today, this is all. For next class, we have to discuss that what are the types of punishment in the modern worlds, and what are the different punishments given in different countries. That also we have to discuss. For today, this is all. Thank you and have a good day, guys.
Is there any 3-year LLB general boys here? 3-year LLB general. All went to court, right? Nobody is here. So yeah, please, exams are going on. Maintain silence. Girls, respective rooms, like yesterday. Please vacate. Girls. 3-year LLB and 3-year LLB honors here. ఇక్కడ ఇంగే 5-year LLB, BA LLB general room number 4-2, BCom BBA 4-7, honors 4-5. Silent up honge. We have exams. Girls, make it fast. Come forward. Please come forward. Girls, please come forward. Boys, leave. Silent up, okay? Silent up, silent up. Silent ആയി പോടാ. Maintain silence, please. So shall we start? Girls, one by one, please come. Okay. Boys also, row in wage. Only few students are there. Good. Don't rush.
No boys.
Only 36 points have been 36. Sir, can you share? I guess we are not. Simon, look at this. 126 only. खाली एक चीज करना है, तेरा चेहरे से मैं हंसी निकाल दूं, खाली एक चीज करना, तेरा नाम और पता, जस्ट गिव मी योर एड्रेस, नेम एंड फोन, एड्रेस नेम एंड फोन. Firstly, tell Karthik to do all this. You won't come to me. Number one. Next step code still go. Okay. Code still ID card है. Okay. ये code को. We have 72 students in the honors. I have only 32 students. 32 students.